In terms of employees who might find themselves suffering from some type of medical, physical, or mental disability, oftentimes employers receive what we call requests for accommodation. These are employees who are asking for a variation in their typical work day, in their, for example, physical workspace, in their work hours, or in their work location. Nowadays, especially with the availability of telecommuting, most anybody can perform at least some functions from an outside location, such as their residence. And that oftentimes ends up being a request from people who certainly have suffered some type of physical incapacitation where it has become difficult for them to commute to the workplace. The question becomes always, from a legal perspective, whether that request is reasonable. And that's what the courts always look at in determining whether an employer has justifiably or unjustifiably granted or denied a request for such an accommodation. For example, in the scenario where somebody requests to work from home, there may be certain jobs where that is considered to be a reasonable accommodation. But there also are positions, certainly, where that would not be considered reasonable. For example, if the employee was critical to have interfacing communications with clients or staff on premises at the workplace, that is certainly something that will be taken into consideration in determining whether that request is reasonable. So the question of what's reasonable is always gray and a very fact-specific inquiry. If you have any doubts, certainly you should contact somebody for legal advice, and your fact situation could easily be researched in a very short period of time to determine whether there are any other factually similar matters out there that we could use to then gauge whether this request should be something that the employer should grant or deny.